or transhistorical. However hard or soft one's position was on how to frame law's role in constituting class relationship, its materiality seemed beyond contestation to everybody in CLS. So the pushback was a generalized claim that we made that there was no need to assert some natural content to race to understand it as dynamic. We had some language from Kendall Thomas to the effect that race was not a thing so much as a process. But beyond those few opening moves in our arguments with our allies, things got really murky really fast. So people either resorted to high theory to respond or an in-your-face, what you talking about response when they critiqued our race projects. So at an institutional level, doctrinal level, and political discursive level, there was a hole at the center of the burgeoning critical race theory movement. It was clear that the discourse on merit was toxic, even to civil rights advocates, but their capacity to defend affirmative action as anything other than preferential was obscured by baselines that contained and insulated racial power. At the doctrinal level, the pushback against affirmative action was increasingly being defended by, as Devon pointed out, the language of diversity, conceding in the process the legitimacy of the starting position. And when critical legal studies critics argued that rights and law overall convinced people of the inevitability of the status quo, they did not, by and large, understand how law works similarly with respect to the racial status quo. So things might have been, had that twinkle in someone's eye not become whiteness as property. Enter Cheryl Harris. So she, like her article, elegant yet exacting, ethereal yet material, measured but deeply, deeply radical. She and her article were a powerful package whose first moment of acquaintance you will never forget. So Whiteness as Property came onto the scene as an intellectual, doctrinal, discursive answer to a multitude of questions that we didn't really have strong arguments for. At the doctrinal level, Cheryl spelled out in line and verse exactly how the baseline from which action insulating whiteness is framed as neutral and action disgorging vested interest in whiteness is framed as suspect, preferential, and potentially unconstitutional. At the institutional level, nothing more clearly articulates how historically privileged access to elite institutions becomes reified in objective discourses of merit. Cheryl's observations about the reification of whiteness extended directly to uncover power that sits at the foundation of traditional meritocratic defenses of exclusionary institutions. As she states, whiteness as an ideologically imposed proposition, its basis is that a relation between people takes on the character of a thing and thus acquires a phantom objectivity, an autonomy that seems so strictly rational and all-embracing as to conceal every trace of its fundamental nature, the relationship between people. Now, as we experience it and know it here, merit is a relation between people, yet framed as a property of those who occupy this space, as opposed to those who don't. A property whose objective is reinforced rather than disrupted by the absence of particular bodies in this very institution that we sit in. As Cheryl writes, when the law recognizes, either implicitly or explicitly, the settled expectations of whites built on the privileges and benefits produced by white supremacy, it acknowledges and reinforces a property interest in whiteness that reproduces black subordination. And finally, within the contestation between CLS and CRT, the article brought new vigor to the claims that CRT constituted an anti-essentialist materialist project, one that sought to uncover how race was materially constructed and insulated through law, not in a transhistorical, all-encompassing sense, but in the sense of specific historical practices of institutional and political dominance. Now, I want to add one last thing. Whiteness as Property not only brought a full package of answers to some of the theoretical doctrinal conundrums that we had, but it also revealed something equally important in the unfolding of the CRT narrative. In reframing race reform away from liberal integrationist understandings and at the same time refracting more clearly the way whiteness underwrote most elite projects, we're able to add another note to the historiography of CRT, namely that redistributed property from CLS was a condition of CRT's possibility. Whiteness as property then not only grounds an argument around affirmative action as disgorgement of whiteness, it helps us see better when allyships actually did work when they moved in that direction. So many of the relationships that were informed by these different sensibilities that led to the recruitment and the tenuring of that first and second generation of critical race theorists was the product of affirmative action as a way of redistributing legal and ideological knowledge to minority communities to better enable them to compete for resources and power. Cheryl's article helps us recapture not only the moment where someone showed up just in time to build the plane we were flying on, thank you, Cheryl, but also helps us to see and continue to imagine the kind of projects, the kind of alliances that we can approach to use to the task of dismantling the continuing grasp of whiteness. Thank you.